Number 7, New York Bus Operators Compensation Trust versus American Home Assurance.
Good morning, Your Honors.
Good morning. How are you this morning?
I am well.
Good.
My name is Anthony Barbiero, and I'm here on behalf of the New York Bus Operators Compensation Trust. And
So I'm going to ask you to go easy on us because this is a very complex case.
well,
He thinks it's easy, but that's okay.
I'm
All
glad you
right.
said that, Judge.
Huh?
I'm glad you said that because I thought it would be a great bar exam question.
Oh, did you? But we're
did.
not in law school. So I thank you for that. But let me start by asking you, what relationship, if any, is there between your argument relating to insurance law 3420 and the statute of limitations defense? In other words, assuming we agree with you that insurance law 3420 D2 applies here, and even assuming we agree that with you that American Home did not comply with that statute, how does that render this action timely commenced?
Fine, thank you. And I'm glad we got right to the point because, as you know, it's our position that the disclaimer is invalid. Now, you have to, when you say those words, you have to understand what that means. That means that the condition in the policy for notice of claim to the insurer has been waived, or that the rights under the policy have been restored. The courts have used that language interchangeably. So now we have a policy of insurance. The policy is to indemnify NYBOT, New York Bus Operators Compensation Trust, for its claims. And the policy provides specifically, which the court did not pay attention to, the lower court, those claims don't arise until you pay. So we have a long-term indemnity obligation expressly implied, expressly contracted to pay for claims only when the claim is paid by the insured. That means that once the 3420 rules are applied to this case, the policy is unconditional. The service in 2020 is timely only to claims accruing 6 years before the complaint was served, pursuant to 3420. Now, in Ironshore, the court was faced with a similar claim, and you laid out the format for looking at this. So the first thing we have is claims that arose within 6 years, adjusted for the tolling statute, because as you know, the COVID toll took place during this period. Those claims were entitled to partial summary judgment, and that's why we cross-moved for that. And if you'll notice, this is exactly how I pled the claim.
I want to ask you one question.
Yes.
And do you have any cases in which an insurer's failure to comply with insurance 3420 D2 is affected the running of the statute of limitations on a breach of contract claim?
No.
Okay.
There are no such cases that I could find. And of course, you know, it's a New York statute, so no, I don't. But I have basic contract law, which we cited in the brief, that where you have an indemnity obligation that only accrues when the indemnitor has made the payment, the statute can't apply until payment is made. So we start with...
So you use some language in your papers. You claim that the notice of denial here was a nullity. Again, what case law do you have that supports that?
we've cited numerous cases in our brief that indicate that
But
when...
none with that language nullity.
No, I think restorative, I think probably that's a poor choice of language. I think restorative, the condition is now waived and the policy is restored to being unconditional. That is all we need to get to the first layer of coverage that we're entitled to, which is summary judgment on 6 years prior to the filing of the action.
So if we just take a look at the language of 3420, how does it apply to a group self-insurance trust like NYBOCT bringing a claim against an excess insurer?
Well, we first look at the Commissioner of Insurance, Salvatore Curiali, in 1994, who wrote an opinion making it very clear to the insurance industry that if you wrote one of the excess policies that he required self-insurers to provide to prevent the exposure of the insurance trust to an excess loss, if you wrote that policy, you'd better know that that policy is going to be covered under Section 3420. He published that order, and my learned counsel has said, well, it does say what it says, but it only applies to self-insurers, individual self-insurers. It doesn't apply to group self-insurers.
So let me give you an example.
May I just finish that thought, though?
Very quickly, because I'm asking.
I only need a sentence.
Okay.
Insurance law, Section 50, 3A, which is the genesis of this policy, says that a self-insurer and a group self-insurer shall be referred to as self-insurers.
So let me give you an example. The statute requires that a written notice of denial of coverage be given to the insured and the injured person or any other claimant. That's 3420D2. Here, is it your position that American Home was required to send a denial of coverage to the employee herself?
No, because as the commissioner made clear in his opinion, the injured employee has no direct right against the insurance company. The injured employee has a direct right against the trust, who is sitting here saying, we should have been paid.
Okay, but, if you agree that this is not the type of circumstance that mandates sending a denial coverage to an injured person, might that indicate that insurance law 3420 is not meant to apply in these sorts of circumstances?
Well, Judge, I must tell you, I didn't expect that question because the insurance...
Well, we like to give you a few surprises.
Okay. Well, the insurance law makes it very clear. Now, this case law, this is the legislature. The superintendent of insurance is in charge of determining how his policies apply. And he said in 1994, as clear as day, that this policy is one that fits under Section 3420. I don't think I can say more than that.
I see. So if Gallagher Bennett was an authorized agent for submitting the plaintiff's claim to American Home, why wasn't it an authorized agent for receiving American Home's denial of that claim? How is American Home supposed to know the difference?
Thank you for that question. It's Gallagher Bassett, and they'll be up here shortly. Gallagher Bassett is a third-party administrator who's charged. Let me just interrupt myself for a second. One of the reasons that could be argued is because the motion court found that they weren't agents, as you're going to hear in a case that's coming later. But I'm not relying on that because I think the motion court was dead wrong on that subject. They were agents. They were fiduciaries. But they were agents whose duty was to present the claim. They can't be agents with an implied duty to accept the claim because it's their liability if the claim is not reported to the insured. So what happens is they're agents to present the claim, but because of the conflict of interests, we have Sierra in the Court of Appeals makes this pretty clear. They're not somebody who you would expect could be trusted to advise the insured of the denial of claim. And of course,
So they're not agents.
so they're not agents with authority to receive the denial, but they are agents with implied authority to serve.
So would you agree with me that the policy does not specify what address was to be used for sending
would not agree
notices
with
of
you at all.
denial? Okay, would you?
I would not agree with you at all.
Mhm.
I think you read page 1 of the policy.
The only provision from my reading of the policy that discusses mailing notices is the provision relating to canceling the contract.
I want to show you this.
No, but
That's the policy.
I believe it or not, I looked at that record. What I'm asking you is, would you agree that the only provision of the policy that discusses mailing notices is the provision relating to the canceling of the contract?
No.
Re-
I'm going to
okay,
read
so-
it to you.
mhm, read it to me.
Item 1, named insured and mailing address. Named insured and mailing address.
Right?
New York Bus Operators Compensation Trust, 176 Washington.
What does that have to
Avenue,
do with,
Albany, New York.
that may be the
1-
address that's in the contract, but that's not what I asked you. I asked you sending no specific notices, and you said that it was there, so I'm,
I'm sorry.
all right.
Did I just answer your question?
You did and you didn't, but it's okay.
Well, let me fully answer it. This court is famous for honoring contracts.
Right.
If this contract were to say this address or at any other address, as they easily could have said, I wouldn't be making this argument. But it doesn't say that. And we hold them, especially an insurance company, to the language of their policy. They
Can
have
I
an
ask
obligation
you-
to send it to this.
I'm sorry to interrupt you, but let me ask you a question, one more question. Was that the current address for the plaintiff?
No, it wasn't the current address of the plaintiff.
And so what address was American supposed to send or use?
Well, the American was supposed to send the address to New York Bus Operators by contract to that address. It's not whether they were staying there. We have mail forwarded. There's all sorts of things that could happen for us to get that mail. But that's their contractual obligation. And there are cases that hold that the fact that the party was no longer at that address doesn't relieve the obligation, the contractual obligation to send it there.
But counsel,
Especially
isn't
where
that
in
for
this case-
cancellation purposes? Isn't that for policy cancellation purposes?
I don't read it as such. Let's read it again. It doesn't say anything about cancellation. Cancellation comes later, and you'll hear from Ms. Alstrom that cancellation comes later in the policy. That's a different provision. This is a general mailing address for anything, especially a notice, disclaimer of coverage.
So you rely in part upon equitable estoppel, is that correct?
Well, may I then rest on my brief
Oh.
for the remainder of the argument that we're entitled to partial summary judgment going back 6 years as adjusted for COVID from the filing of the summons and complaint. Oh,
I see you are a very experienced attorney. Thank you very much for your argument. You may.
so now, estoppel?
No, but I don't need you to answer it. I just said, thank you for resting on your brief.
No, I'm sorry. On that point,
Yes.
you asked for estoppel.
Yes.
Oh, I did want to discuss that with you.
Oh, okay, so then, So how do they, so then I should ask you, so how do the equities weigh in your favor, given the plaintiff knew about the defendant's 2012 denial letter by 2016, and therefore could have commenced a timely action against the defendant?
The timely action that could have been commenced in 2016 would not have been, was 2 years after the uh, truncated the statute of limitation from 6 years to 2 years. So the argument is that if you examine, and of course this is a factual examination, if you examine the conduct of the carrier and you determine that the conduct of the carrier in waiting 80 days to deny a claim when the claim was presented 12 years after the incident, 9 years, 17 and 2007, I believe that the court found was when it hit the self-retained retention. 9 years after that, the first question you ask is, how is it that you didn't notify this insurance company with a mailing at an address that they was likely to get it? How is it that you sent a letter addressed to the New York Bus Operators Compensation Trust at a place that they had no contact with? How is it that you claim you picked up a telephone to call New York Bus Operators Compensation Trust? You had to be told, this is the trans group. They didn't answer New York Bus Operators Compensation Trust. How is it when you heard that Gary Woodstock, actually Woodcock, but he was told Woodstock, or he says he was told Woodstock, Gary Woodstock doesn't work here. How is it that you didn't just hang up and say, I got to do something different here?
So I'm going to ask you one more question. So that is, why didn't the plaintiff commence an action against the defendant at the same time it commenced its action against the third-party administrators?
I mean, why did not?
Yeah.
Well, I don't think that the attorneys who were representing the plaintiff at that time understood the relation back doctrine in an indemnity situation. And when we brought it to the court understood it, and the court granted us the right to go back 6 years on the network adjuster's claimant's liability. So why not? Why not American Home?
I got it. So, Mr. Barbiero, do you want to add anything else that you haven't mentioned thus far?
Well, you know, I have to mention the court's reasoning claiming that NIBOC, as an insurer, is not entitled to notice. That can't stand. For that reason alone, this case cannot be cited for that proposition. NIBOC, the court looked at the character of NIBOC's business. Are they insurers? The other insurers under Section 1108, special insurers that are not licensed but can write this limited type of insurance. Are they auto mechanics? Are they some other profession or business? Are they supermarkets? What difference does that make as to notice that they're entitled to? Thank you. What difference does that make with regard to the notice that they're entitled to? That they're in the insurance business makes no difference. The difference that determines this case is that they're the insured under the policy. And Bovis, the case cited by the lower court as authority for dismissing this claim, directly holds that to be the case. So with that, if there are no other questions, I'll rest on the brief.
I thank you for your first argument.
Thank you.
Good morning, Elizabeth Allstrand for the respondent. I'm going to jump around a little bit because you
So
covered quite a
let
bit.
me focus you a little
Sure.
bit by asking you, why doesn't Insurance 3420 apply to the claim by a group self-insurance trust, such as the plaintiff, And aren't they the insured?
So there's a couple reasons why it doesn't apply. First, with respect to this claim, this was an excess workers' compensation claim, and the very nature of the workers' compensation coverage is no fault. It's not these aren't liability claims. And in particular, on the excess layer, they were operating really as a reinsurer. You have to recall that the group has taken a collective group of risks and put them together. And when you look at the Attorney General's letter from 2000, they are operating very much in the same manner as an insurance company. They're taking collective risks, they're sharing those risks. And then in the excess layer, they are pushing their own risk, collective risk, up to another layer. That's very much like insurance, primary insurance, and reinsurance. And so when counsel's referring to Bovis, Bovis talked about whether 3420 notice really applies to disputes between insurance companies. And we would put forth that this is really a dispute between New York Bus, the trust, acting as an insurer for its member companies, and American Home as a reinsurer or an insurer on the excess layer. And really, when you look at the purpose of 3420D also, you go back to the legislative history that the First Department looked at in Bovis, it's to protect the claimant and the claimant's ability to collect on liability claims. And again, a workers' compensation claim is not a liability claim. They're assured recovery. And so the underlying principles that gave rise to 3420D really aren't present in this case. And while I realize that the circular letter that opposing counsel relies on does talk about 3420, it is limited to individual self-insurers and not group self-insurers. And they really are very different. And also that letter only says that the applicable portions of 3420 will apply. And it's our position that this provision in 3420 is not one of those provisions.
So even if 3420 doesn't apply, because you mentioned doesn't apply to be between co-insurers, is this really a case involving co-insurers?
This is not a case involving co-insurers, and certainly Bovis dealt with co-insurers, but I think the basic principles are the same, is that the underlying purpose of 3420 is not being served in insurer-insured disputes. And from our perspective, the distinction between a reinsurer and an insurer versus co-insurers is not significant. But I would also offer that 3420, whether we violated it, whether it applies, is really irrelevant to the statute of limitations issue. And
So I was going to ask you about that. So assuming that we agree with you that the insurance law 3420 doesn't apply here, if you apply common law principles, did the statute of limitations ever begin to run if the denial letter was not served?
Yes, because there's no discovery rule in contract actions. And also, when we look at waiver and estoppel relative to the statute of limitations issue particularly, certainly there was no conduct on behalf of American Home to intentionally relinquish the statute of limitations. It never, made any indication that it intended to do so. And with respect to estoppel, its conduct in failing to serve directly New York Bus, if we assume that that's the case, that action didn't lull them into sleep and to sit on their rights. They sat on their rights for 2.5 years because Anderson Kill instructed them not to file suit against American Home. And I think that that's really kind of the death knell to their estoppel argument. Also, in terms of looking at estoppel law, it cannot be the underlying conduct that is the basis for estoppel. So here we have the underlying conduct is we issued a disclaimer and we didn't send it to you. That's the underlying conduct. There has to be some other conduct that is lulling the participant into sleep, and we don't have those circumstances here as well.
Is there anything else you'd like to add?
Just to go back to 3420, even if we did violate 3420, our position is that that has no impact on the statute of limitations. the consequences, the recognized consequences of a violation of 3420 is that the carrier has waived the condition or the exclusion. But that waiver, that consequence goes to the merit of the breach of contract claim. So we issued a disclaimer, and if it is not legally sound because we waived the basis for our disclaimer, that goes to the merits of the breach of contract case. That's not any different than when you have a circumstance where an insurer issues a disclaimer letter and the policyholder disputes that that's an applicable provision. And so whether the issue arises out of 3420 or some other basis that the policyholder has raised, the statute begins to run, and if they want to challenge the basis for the disclaimer, they have to do it within the 6-year statute of limitations. Unless your honors have other questions.
Thank you,
We'll rest
Bob.
on our brief. Thank you.